special guest, Mary Ann Pidgeon. Yes, we're going to talk about estate law, which is very important and very relevant to current markets, and but a little bit different too from normal transactions. So let's welcome Mary. And she would like one of each of your business cards. So before you leave, you have to give her a card, and we have her cards up here. There's also a handout for today if you didn't get that already. Did everybody get a card? Not yet? We'll pass them out. And I'll just turn it over to Mary Ann and let her take it away. Let me know when you want to pull the screen. I'll share the document.
All right, thank you very much for having me here. You all are wonderful to work with. You're very professional, so I'm delighted to be here. I'm honored that you invited me. I know your time is precious, so my goal is to give you some facts that will help you deal with this certain situation. So it's very common, probably what, 1 out of 20 or 1 out of 30 of our files. You walk in, a kid calls you, a surviving wife calls you, dad is dead, we need to sell the house, what do we do? And there's a lot of emotions. There's a lot of emotions in all real estate, but when you're dealing with dead people, you're going to have to deal with it because they're dead people. And we're all going to be dead someday, so we've got to face it and deal with it. But I think it's good. I think it helps. I do estate planning too. I write wills for people, and I say that it's good to face death and prepare for death because it affirms what a wonderful life we have, and it's also a gift to your children. So, so maybe I should start back there. I have a master's in taxation and estate planning. That's a degree above a law degree. I went to school for 5 years at night, which was insane. But I have this wonderful knowledge that I felt that I wanted to be a very good estate planner in addition to my real estate practice, because everybody after they did a closing, they would say, well, do you do wills? And I would refer it to somebody, and the person kept saying, quit referring it to me, you do it. And that's a very wonderful guardian angel type of person. So I went to school for 5 years to learn how to do it. And it's really intersected nicely with my real estate practice because so many of our clients are deceased, and we know how to handle it because, you've got a track for a live person, you've got a track for divorcing couple, but very often this track for the dead people, you're in the dark about. So please save this, and if you're called to deal with a dead client, this will just give you an overview. And you certainly don't memorize it, but at least the terms will be familiar and you can guide your clients accordingly. Because when you walk into that room and they say, please help us sell the house, filled with all the emotion, and there's all different kinds of emotion. I mean, there's like yippee, there's I'm so sad, or there's going to be conflict. So you're walking into a lot. So I think if you have the legal facts, at least you're grounded and you can start there. So the first thing to determine when you walk in is who owns the house, because it's amazing, the kids, the one I had this year was dad owned the house and he had a big trust fund. So he met a woman online, of course, and I think actually it's a newspaper ad. Good-looking woman wants elderly man for company, and so before long she moved in, and lo and behold, he had transferred half of the house to her. So dad died, the kids go in, and they holy crap, we own half of the house with this crazy woman who has lived with him. So they tried to litigate, and they spent a ton of money trying to get her off the deed due to undue influence and other things, but it didn't work. So they ended up just getting half of the proceeds of the house and having a lot of other tax problems. So I think the first thing that you do is you comfort them, you talk to them, oh, we'll be ever so happy to help you, but then get a copy of the deed. And if it says they're husband and wife, civil union partners, or tenants by the entirety, then you're cool. Then it automatically goes to the surviving spouse. In an ideal situation, we give people a big blue Pigeon and Pidgeon binder. And in that binder, we have the will, the living will, a copy of the deed, and all the assets. So hopefully, these people have that, and then everything's there. If not, then you'll have to dig to get the deed. And in New Jersey, have you ever run into a tax waiver when you've done one of these closings? So in New Jersey, there's an inchoate tax lien. So that means it just automatically goes on all real estate. And that is in regard to the inheritance tax. So that's going to flip out mom, it's going to flip out the kids, but it doesn't apply to mom or kids. It applies when you leave a house to like the girlfriend that you're not married to, or your next door neighbor, or your niece or your nephew. Then New Jersey slaps them up to a 15% tax on that asset. But the law doesn't care about that. They put it on all real estate, and then we have to file a document to say, well, that doesn't apply to us because we're the mom or we're the kids. So you have to get a tax waiver. But I don't know that you need to tell them that the first meeting, but that's going to happen down the road. If they own the property as tenants in common, that's problematic too, because that means that half of the house goes to one person and half of the house goes to another person. And this is, and I'm going to tell you lots of stories because this is dry. Taxes and death are dry, but the stories related are not dry. So tenants in common, if an attorney or a title company drafts a deed and they don't put, and they're two unmarried people, they have to address what happens to this property when one of them dies. So if you say to, Joe and Sue, you're not married, so if Joe's hit by the bus, do you want Sue to inherit it? So that would be joint tenants with right of survivorship. If you want your mom and dad to inherit it, then it's tenants in common. If they leave it blank, it's tenants in common. So my sad story about this issue is that probably 20 years ago, a woman went out to walk in Plainsboro on the pond to chase her dog. And lo and behold, she went into the pond. Does anybody remember this, or I just remember these gruesome stories? Went into the pond and drowned. For 19 years, she lived with Joe. They bought the house together. They paid the mortgage. They paid all the maintenance together. Went to the attorney after she was buried, and nothing after their names. It was, didn't say tenants in common. It didn't say joint tenants with right of survivorship. So the default in New Jersey is tenants by the entirety. So Joe ended up owning half, and the deceased partner, her children owned the other half. So despite the fact that it was their intent that it would go to each other, they bought it together, they paid together. The children, of course, said, Joe, you're a wonderful man, but the hell with you. We want half of the value of the house. So they forced Joe to sell the house on a suit for partition. It had to be sold. They got their half, and Joe was, all I can think of is screwed. That's not really the right word. but he was, yeah, he was in a pickle. So that's why it's so important clients have to look at the deed. The attorney has to have that conversation with them about what happens when you're hit by the bus. So then the next question is, after you get the deed and determine who owns it, and if we have any potential sad stories, call me and let me know. I can add them to my repertoire. You say, did Joe have a will? So if Joe has a will, your life's a lot easier. And the surviving spouse, and children, everybody's life is a lot easier if there's a will. So you would get the name, you would get a copy of the will, and then the person who names the executor is the person who has the authority to sign the listing agreement. So that person is your new best friend. But all the time, we have listing agreements, we have contracts signed by some other person, because it takes a while to be named the executor. You've got to send the death certificate and the will down to the surrogate, so it can take a couple of weeks. But for your purposes, you want to be sure that you're talking to the executor, unless they don't want to serve. But you've got to talk to whoever is the person who's going to have the authority to sign the listing agreement and the contract. But it's common practice for a person who has no authority to sign. If you do that, know that they don't have the authority to sign, but be sure that you follow up and get the right person who has the authority to sign. The authority to sign is given by the surrogate, who issues what's called a short form. And it actually is a short form, and it says that Sue is appointed executor. She has legal authority to do everything that needs to be done to wrap up this estate. In order to get this, Sue's going to have to get together, and just so you know what your client's going to have to do. They're going to have just to have a rough estimate of how much is in the estate, because the surrogate wants to know that. They want to know just a general estimate for how much the debt is. And again, at this point in time, when you're going in there, like within days or weeks after the death, people might not know yet. So it's okay to just estimate that. And then the surrogate's office also wants to know the total amount of the estate. There's no New Jersey estate tax. As I said, there is an inheritance tax. So if somebody's passing just to their kids, there's no tax, but the surrogate still wants to know the size of the estate. The things that affect you about the size of the estate is there enough money to sell this house, pay off the mortgage, pay our realtor friends and our attorney friends? Because sometimes there isn't enough money. And this is another story. We had this niece who was named executor. She came into her office, and her uncle was 82, and he owned a condominium at Roswell. And he got a mortgage. His wife died. He got a mortgage for like the full amount due. Got on a cruise ship, put all the money into this cruise, took an around the world cruise, and of course he died in Australia. So here's this niece. I'm just getting, I'm on new blood pressure medicine. One of the joys of age. Yeah. So he's on the cruise, dies. Think about what it took to get a body from Australia back here to bury it too. So it's this poor niece. And then she added up all the debt, and the condominium and his assets were worth $100,000, and he owed $150,000. So the state realizes that real estate still has to move. So the law is on our side. So what we had to do was we had to file a motion, and it's called sorry, I'm getting this. It crams down the debt. So we were very lucky. The mortgage company agreed to cram down the debt so that the administration expenses, the realtors could get paid. And then the mortgage takes a hit. Sometimes though, when we litigate, the mortgage company refused to take a hit. And then we have to go through longer litigation, and it's really a problem. But when you have insufficient assets like that, you've got to, we've got to make sure that the realtors get paid, the attorneys get paid, and then the cost of administration get paid. So that's a good thing to just keep in the back of your mind too, is when you're taking a listing, are they going to have enough money to pay the bills?
Mary Ann, can I ask one question?
Yeah, please.
I should remember this. The executor is named in the will as well, right?
Yes, the executor is named in the will. Hopefully, there's a will, and hopefully the person's not dead. So that's why, if you're hearing my subtext, please get a will if you don't have one, and please get it updated so you don't have dead executors. So that's my subtext. So the executor is going to have to provide an estate inventory, and then when they get to closing, there's a whole different track of papers. The title company will want to know the assets and the debts, and the title company will also make the executor sign an indemnity bond. So that means that if any debts come up after closing, the executor still has to pay them. Then for closing, there's a different deed and a different affidavit of title. And then the check for the proceeds of the sale is either made payable to the estate or the named beneficiaries. Now, sometimes you'll know that the attorneys have to jump through hoops if there's any question about things. They might want the beneficiaries all to sign off on a deed. So if you see that happening, then you know that there's some issues that the title company wants to make sure that the executor is on the same page with the beneficiaries, and the title company doesn't have to worry about the beneficiaries coming back later and saying, why did this check go here? So you'll just see these things peripherally. So now I am moving to the top of page 3. What if there is no will? So you should double your fee. Because then you're sitting in the room with these people and they have to figure out who's going to act as the administrator. So it's an additional different track, with a different checklist. So that's the person, again, that's going to be your best friend. That's the person who will sign the contract and the listing agreement. Sometimes that's problematic. And the surrogate's court has a hierarchy. So they would look to the wife first and then the children. So if the wife is 110 and she doesn't want to do it, she would sign a renunciation. And then the administrator will take the will, take the death certificate to the surrogate, and then the surrogate processes a different form, appointing them administrator. Now, the big difference is that if you don't have a will and you've got to deal with an administrator, you've got to post a bond. So if you think getting a will drawn, I charge $1,500, but for realtors I charge $1,200. But it's a package, it's a wonderful experience. I'll kill you, I'll put you in a coma, it's worth every penny. The cost of a bond is going to be a heck of a lot more than $1,500 because the bond's based on the size of your estate. It's an extra hoop you have to jump through, an extra expense. And all you have to do is come see me and get your bill done and avoid that. So once that is done, and then look at E in the middle of that page. Now this might make your hair hurt. This is New Jersey statutory law. So everybody thinks, okay, if I die, my husband's going to get it or my kids are going to get it. I don't need a will. I know where it's going to go. That's not true. If there are no surviving parents or children, then your surviving spouse gets it. But look at this chart. I'm not going to read it to you. But your parents can get some, your surviving spouse can get some. If you've got children from a prior marriage, if you've got current children, it's not what you think it is. So just have a look at that. It's New Jersey statutes. You're used to New Jersey statutes. It'll make your hair hurt, but it's not as simple as you think it's going to be. So hopefully our clients won't have to deal with that. They'll all just come and get my will. So the attorneys have to prepare an estate inventory, the indemnification bond, the administrator's deed, and the administrator's affidavit of title. So when you're out there doing the walkthrough and getting all of the inspections done, we're charting this course with this different set of documents and different requirements. it impacts you to the extent that your sellers will have to be jumping through these hoops too. So if they have any questions, or at least you can sympathize with them about what they've got to do to get their house sold. So a tax waiver or a tax return may or may not be needed. So this has to do with the inheritance tax. So if you are passing to the Class A beneficiaries, like the husband and wife and the kids, then we just file an L9. It says that no tax waivers needed, there's no tax due. If you do have to pay an inheritance tax, well, wait, let me go back. Have you all heard of the civil union partner? Okay, so these things are a wonderful thing, because if Joe and Sue, Sue went through the ice, remember, to get her dog in Plainsboro. If they would have gone to the Plainsboro Township, lovely town hall, and filed papers to become domestic partners, civil union partners, then you avoid the inheritance tax. He would have inherited the house. It's a wonderful thing. You can also have, in case of emergency, you can have access to medical records without having the HIPAA release. So if you're in that situation, look into that, because it's a wonderful thing. And remember that any unpaid inheritance tax is a lien, and if the heirs are a cousin, a sister, or a friend, a 15% inheritance tax must be paid. So what we do is, it takes a while to get those returns filed. So what the title companies do, we just did an Aspen. So Aspens are about, I think it was 230,000. The title company held 7,000 or 70,000. So when you're talking to your sellers and they say, why? You can say, this is common that these escrows are held until the tax waiver is issued from our good friends in the Division of Taxation, showing that the amount of money that we paid on the tax return is accurate. Because I think it's sometimes our sellers that can make their hair catch on fire. But it's interesting that different title companies treat the issue differently. So some title companies, we send them our tax return and say, we had $1 million estate, given it to the brother, we paid $300,000 in taxes, and they're, okay, that's fine. No money held. But most of them, and I think a good title company, should hold the money. So just say to your sellers, as soon as the Division of Taxation says your tax return is just peachy, you will get the money back. It may sit a year, so hopefully they don't need that cash. But again, just so you're prepared and you understand and you can calm them down. And I guess one of the primary things is, as soon as you go into the room at that first meeting, direct them to an estate administration attorney. Because it's much easier for us to interface with the surrogate and get all the appointments, as well as to get these tax return issues taken care of. So we're at summary. Yay, you guys, you made it. Any questions at this point?
Question. When you spoke about civil union partner, that they need to file to become domestic partners. What if they're legally married?
Oh, then that's better.
Right.
Legally married is totally the best, legally speaking, in terms of individual benefits, individual rights, in terms of inheriting pensions, protecting your interest in pensions and IRAs. Get married.
So there's a difference.
Oh, geez, yeah.
Okay.
If you're married, I have another story, and these, we gotta have this. So lady comes in, husband went on vacation to Haiti, left her with 2 kids, said, ooh, man, I like Haiti. I am not coming back. Lives in Haiti. She went into HR. She's with a big pharmacy, has large benefits. She said, I want to take that stinking guy off my pension. No can do. No can do. Under, you know, the law, the spouse has to sign off. Now, the flip side of that is the jerky husband, and what if he had the big pension? He says, I want to get my wife off of it, even though he is the jerk. That's a legal term. You have your jerks and your non-jerks. He couldn't do it. So whatever, you know, we all think about marriage, it's just still better in terms of your legal rights to get married. The domestic partnership, the civil union partnership, they're like a degree under it, but they're better than nothing because you really get them. Yeah, it's bad. And if you've got if you marry somebody who was married before and a lot of times after they get divorced, they redo a will and they leave everything to their kids. So you marry Joe. Joe still has this stinking old will, leaving everything to his kids, but you've been married to him for 25 years. So upon your marriage, which I highly recommend, I also highly recommend getting new wills, because I just had gal got divorced, left everything to her kids, married to the guy, the house, you know, everything. Old will, never changed it, everything to the kids. He got an insurance policy. But then sometimes I have to wonder, well, maybe did she intend to do it that way? But if you don't intend to do it that way, dig into the archives and make sure there aren't any old wills floating around.
What's the benefit of having a trust versus just a will, and also what's the downside?
New Jersey, well, they're good trusts, and then I'll get to New Jersey. We put in every will, we put a trust, a testamentary trust, so it's only effective when you die. The first level is for your children, and you keep it in trust till they're out of college. We had one lady come in, and a husband. They wanted it in trust till the kids were 55. A little bit of control issues there. So children's trust is the first trust. The second trust we use for a husband and wife is a tax-saving trust. Because right now, New Jersey doesn't have an estate tax. If you're as old as I am, you remember New Jersey had an estate tax where they taxed every asset over $675,000. So everybody who had a house or an insurance policy in New Jersey got hit with an estate tax. So, and for federal right now, you each have 12 million. Husband and wife have 12 million. So another reason to get married, then you could protect 24 million instead of just 12 million. So we include a marital trust that allows us to divide your assets into two piles. So we all know realtors are very rich. You've got your 24 million. So what we would want to do is, upon the death of the first, divide one pile into 12 million with a trust and one pile into another 12 million. That way you avoid the tax. Otherwise, if the kids inherit the whole pile of 24 million, if it's over 24 million, the estate taxes are up to 45%, 55% of that amount. One of the best stories is the George Steinbrenner case. In 2000, they did away with the federal estate tax for a year. So George Steinbrenner, I think, died January 2nd of 2010. He died right after that. They took him off life support. But that it's the tax. Well, that's something for that. But the trust for the taxes is the goal to lower those taxes. The other kind of trust, and I'm sure you guys have seen this too, the Revocable Living Trust. Now, the Revocable Living Trust means that, and this is very, very played up. A lot of attorneys did this. They got in some trouble. They'd have people for dinner. Let's do a Revocable Living Trust. The bill's $5,000. In some states like Florida and California, where probate is arduous and horrible, you really do need a revocable living trust, because that just means those assets don't have to go through probate. They can go directly to the named beneficiaries. It doesn't save you any money on tax. It just makes the probate easier. But in New Jersey, probate's peachy, wonderful, takes 2 weeks, well, now because of the pandemic, probably 4 weeks. Yeah, so you don't really need a revocable living trust to save money on taxes. One of the things that it's good for, if you own real estate in New Mexico or Texas or California, and you put all the deeds in the living trust, then you don't have to go through probate in each one of those states. So when clients do have out-of-state property, I like it. But in New Jersey, we don't really need it. I think a lot of times people are trying to scam you because just the regular things work. It requires that all your deeds are changed, all your accounts are changed, everything has to be owned by the living trust. The other thing that is bad for that, in the real estate held in that, is if you're in a trust, you don't get the stepped up basis. Don't know what the stepped up basis is? So the stepped up basis is, grandma bought a house on Nassau Street 50 years ago. She paid $50,000. It is now worth $5 million. The heirs want a stepped up basis so that at the time of grandma's death, the basis becomes $5 million. Otherwise, if the basis is $50,000, they will pay some sort of capital gains on that difference. So that's a factor that mitigates against having it in the trust. Yeah, I would not put any highly appreciating assets. Are there any highly appreciating assets left? But don't put your Apple stock, stock, anything in a revocable trust. Yeah, for most of my clients, it works just fine.
What about if they have property that's the rest of the property, but it's jointly owned with other general partners? How do you?
Sometimes for those, an LLC works, a family limited partnership works, the revocable living trust can work. There are different modalities for that. There's also a trust called a qualified personal residence trust. But again, you've got the problem with the stepped up basis. And what you do in the qualified personal residence trust is it's a 10-year trust, and you slowly, your children pay you for the house, and then at the end of 10 years, your children own the house, and you've got to get out or create a rental agreement. But because of the stepped up basis issue, those trusts are losing popularity. Yeah. Then there's other kinds of trusts, the revocable trust. So say you hate your son-in-law or your daughter-in-law. Some people put their funds, and it has to be an irrevocable trust. So you would put your daughter's assets in an irrevocable trust. And there's been litigation about this, so go to somebody who's an expert and say this money cannot be commingled, it can't be used for common expenses, because we don't want the second son-in-law to get the money. So that's another kind of trust. There are also Medicaid trusts. Now these I really don't like, but there are a lot of attorneys that one attorney I refer to is they're excellent. But this is if you've got, say grandma's 70, because there's a 5-year look back. Grandma can't die for 5 years, so you'd have to keep her alive on life support. And she essentially impoverishes herself. So she gives everything to this trust, so that when she dies, she doesn't own anything, and she could qualify for Medicaid. So grandma's worked hard her whole life. She's going to give away all of her stuff so that she can qualify for the crappiest bed in the institution. So some people, this is a good thing. So I don't want to say too much against them.
They're a headache. You have to create them before
Well,
they
like
turn
what you're
65.
saying.
Yeah.
Before they turn 65, you have to create the trust.
And if there's
There's a whole
a
bunch of
5-year look back, and they work for some people, some families.
Going back to this, you don't like your son-in-law, whatever.
Okay.
So let's say you have a daughter and she's getting married. You have some problem, family problem. How do you go about the deed or just
so that happens in the marriage.
Do not put her on the deed, because then he could say, when he goes to his divorce attorney, she owns an interest in that house, I want that now.
Prior to marriage.
No. If you're in that situation, go to an estate planning attorney and just, they'll tailor something to your specific facts. Because there are things that you could do now to protect in that situation. But it's got to be really carefully drafted, because there's a really bad case on point where it didn't work. And they only made the lawyers rich by litigating it. Anything else? Well, I hope that this has given you some background, so that when you do walk into the room with the tears or the joy or the chaos or the confusion, whatever you walk into, at least you can go back to this and give them some advice. So please go with an attorney, please look at your deed, please find the will, and I hope you all will get your will, get married, what else? Live happily ever after, have a great selling rest of the year, and any questions, let me know.
So thanks, Mary Ann. Also, thank you for bringing lunch today.
Yes.
We have separate cards for contact information on the screen. Thanks for those on Zoom today. And please give Mary Ann one of your cards on the way. This is one of them.
Thank you, thank you. We also are moving our offices. Yeah, Princeton bought our building, and they're slowly taking us over. So they've taken over the top floor of both the buildings. They kicked out the radio station. I'm at Alexander, I'm right down the road, at the corner of Alexander Road in California. And so we're moving to Bond Drive, which is right when you go to the train station. So it's just on the other side of Alexander Road, and it's on the left. It is beautiful. It is so much nicer. It's a Class A building. You walk into this beautiful lobby. We're going to have brand new offices. They have a Peloton. They've got foosball, ping pong.
Yeah.
Yeah. I mean, it's gonna be a life-changing experience. December 31st. And then there's a lake we can walk around, so when people call me and cancel deals, it's like, okay, I'm gonna go walk around the lake. So, yeah, I hope you all come visit us in January. And good luck to you guys. I know how hard your job is. I know how hard it is to get into that room, battle for the listing, battle for the contract, then fight through inspections, mortgage contingencies, appraisals, no, and then the closing. So hopefully, yeah, I wish you all the best with all your transactions.
Thanks.
All right, thank you.